Hi, Aditi. The rest of the attendees will continue to log in. I request you to begin with the introductions.
Sure.
Okay, let's go ahead. Start.
Good afternoon, dear panelists, the audience, and the organizing team. It is my pleasure to welcome everyone to our expert panel discussion on review of arbitration developments in 2020 and effective case management at SIAC. I take this opportunity to introduce you with our organizers, Lex Witness and Society of Corporate Legal Experts. Lex Witness is India's first magazine on legal and corporate affairs. For over 10 years since its inception in 2009, as a monthly magazine, Lex Witness has become India's most credible platform for the legal luminaries to opine, comment, and share their views. Society of Corporate Legal Experts is an organization that aims to bring the fraternity members worldwide and the students of law and commercial disciplines to come together for sharing their thoughts on commercial laws, policies, and current trends in these laws. I now introduce everyone with the esteemed moderator, Mr. Zameer Nathani. Mr. Nathani is an LLB LLM in civil, corporate, criminal, customs, international laws, UN, WTO, PhD from Harvard Business School, Executive MBA from Narsi Munji Institute of Management Science, US IP laws from Stanford University, intellectual property rights and area certifications from WIPO, United Nations, private equity from London Business School, and M&A from Harvard Business School. Mr. Nathani was a law firm attorney for renowned and global corporates such as Eureka Forbes, LG Electronics, TCL India, Motul Oils, Ginger Hotels, Kale Consultant Softwares, Johnson & Johnson's, other MNCs from US, UK, Asia Pacific, etc. He was Associate Vice President for Reliance Entertainment, Digital Business, Global, Gaming, OTT, and E-commerce. Head Legal for Balaji Telefilms, India's #1 TV show company and OTT, and Director Legal for Raymond Limited, world's largest producer of versant suiting fabrics. He's presently Senior Vice President and General Counsel for UFO Movies India Limited, India's pioneering and disruptive technology developer for digital formats of all movies and other content for movie theaters and new OTT and UGC platforms. Mr. Nathani is a recipient of the prestigious Harvard Business School Alumni Challenge Award from Harvard Business School, Alumni Achievement Award from Narsi Munji Institute of Management Science, and in addition to other renowned awards, in the past, he is also a recipient of the General Counsel of the Year Award from Indian National Bar Association at the gracious hands of Justice Sri Krishna, ex-Judge Supreme Court of India, and Chairman of the Committee on Data Protection Laws. I now request all the attendees to place all their questions in the Q&A box visible on their respective dashboards. Here, you can upvote and comment on the questions as well. We will try conducting a live Q&A session towards the end of the event. However, in light of the time frame we have and the number of questions, we would prefer the questions coming from the Q&A box. Please have a look at your chat box where the webinar help desk will be posting updates regularly. I now request Mr. Nathani to take it forward from here.
Thank you. Thank you very much, Aditi. And thank you, everyone. Welcome to the program on review of arbitration development in 2020 and effective case management at Singapore International Arbitration Center. I first of all wish you a very happy New Year 2021 and pray that this new year is really filled with great opportunities, good health, and success for all of you. I want to thank Lex Witness, Singapore International Arbitration Center, Society for Corporate Legal Experts for organizing this event. This particular event, when we gave a thought process to it, is been divided into two parts. One is what are the developments in the arbitration field which have happened in terms of the judgments which have come, which we will give you snapshots of it so that you really take home the knowledge sharing which is going to happen from the panel. And the second part of it is we are going to make a presentation to you on the effective case management at Singapore International Arbitration Center, also to add on the rules and the procedure part of it. My esteemed panel members for today on the subject of review of arbitration developments in 2020 and effective case management at SIAC are First I have is Mr. Rajendra Mishra. Rajendra is Executive Vice President and General Counsel of the Indian Hotels Company Limited. Well-known brand is the Taj Group of the hotels. Rajendra is a seasoned business legal professional with more than 24 years of experience in the legal field. During this period, he has served also as an in-house legal counsel for several leading business corporations like Hindustan Unilever Limited and ITC. Rajendra is a stalwart of the global corporate legal world with his rich, stellar, and scholarly experience and knowledge. The legal and company secretarial functions at the Indian hotels also report to him. He holds a bachelor's degree in law from University of Calcutta, postgraduate diploma in patent from Nalsar. He has also completed his Hawksmere course on intellectual property law from London. Rajendra also has a certification from Harvard Law School. Welcome, Rajendra. My next panelist is Mr. Abhishek Malhotra. Abhishek is the founding and managing partner of TMT Law Practice, a very well-known law firm in India. Abhishek is a well-known lawyer in the field of technology, media, and telecom, including arbitration practice. He has nearly 2 decades of experience in the legal realm and is a member of both the state bars of California, USA, as well as New Delhi, India. His primary areas of expertise are intellectual property, dispute resolution, and technology, media, and telecommunication industries. The firm represents a broad range of clients, including Fortune 500 companies and government authorities. My next panel member is Mr. Kevin Nash, Deputy Registrar and Center Director for Singapore International Arbitration Center. As Deputy Registrar of SIAC, Kevin assists the Registrar in the administration of cases filed with SIAC and the supervision of SIAC's multinational secretariat. In his previous role as counsel at SIAC, Kevin administered more than 250 arbitrations under various institutional rules, including the SIAC rules and UNICITRAL rules. He also handled numerous cases conducted under the expedited procedure and emergency arbitrator applications for urgent relief prior to the constitution of a tribunal. Kevin holds a BA from Mount Allison University and a JD from Osgoode Hall Law School. Kevin worked at one of the Canada's prominent Seven Sister law firms and then went on to study LLM in international commercial arbitration at Stockholm University. He is qualified as a barrister and solicitor with the Law Society of Upper Canada. Ms. Shwetha Bhiduri is the head of South-Aisa SIAC. My next panelist, Shwetha, is the face of SIAC in India. Shwetha is very well known in the dispute resolution practice, and prior to joining SIAC, she was also associated with well-known and leading law firm in New Delhi for nearly a decade on commercial litigation cases as well as investment treaty arbitrations involving foreign and Indian investors. Shwetha holds a master's degree in law. Shwetha has also worked on many leading cases which have contributed to the development of law affecting global companies. When it comes to SIAC, Singapore International Arbitration Center, as we all know very well that this is a very old organization, very well-known organization globally. It's an ADR forum, and apart from Singapore and India, it was recently in news for opening office in United States. SIAC has a history of innovation to meet the developing needs of its users and improve the efficiency of the process. In 2010, the SIAC introduced provisions on expedited procedure and the appointment of an emergency arbitrator. I would like to welcome all my panelists, and I really thank you for your time and efforts for this particular event. Going forward, before I start the part of the developments, what have happened in the arbitration sector 2020 in India, and one cases of glimpse in United States, and then we shift our focus to the SIAC rules and procedures. While we just spoke about emergency arbitrator and emergency arbitration, this was almost in the news because we had recently a subject matter between Amazon and Future, which has gone to SIAC. For emergency arbitration, we could only say that recently SIAC was in news as the Amazon and Future group deal hit the headlines and Amazon moved to emergency arbitration for stay on a competitive deal by Future. And an emergency arbitrator granted the stay, and presently the arbitrators have been appointed for the substantial arbitration to commence. Uh, while making this statement, we are conscious of the fact that we also have members from SIAC who are on this panel, and therefore, just to avoid the conflict of interest, I would request my audience, when we are on the SIAC part of it, just to avoid the merits discussion of this case, because this case is presently before SIAC, and we would like to avoid direct questions on that. However, we would answer general questions on the rules and procedures as may be required by the audience. We have a great menu for our dear audience. We are going to first give you the snapshots on the arbitration developments and cases in 2020 in India and United States. Credit to Advani and company. So that you get immense knowledge on the arbitration cases and judgments of 2020, and which will be then followed by a presentation on SIAC rules and procedures, so that you have a maximum takeaway in the most simple and lucid manner, which we are going to present to you. Once again, to my audience, because this subject matter is so important and international arbitration is now growing up in the markets all over the world, we are going to make this very simple for you. We have our panelists, Rajendra, Mishra, Abhishek, Malhotra, and myself, who will speak for about 5 to 7 minutes and give you a snapshot of 8 India cases and 1 US cases each person by saying the name of the parties, date of the order if available, what is the question which came up before the court or the Supreme Court, and what was the answer which was given by the court or the Supreme Court. This will give you the glimpse of the judgment, so that you get the maximum out of it, that what was the conclusion of the court. And that's how we are going to brief you on the knowledge sharing on the arbitration cases. Then we move on to the second leg, where Kevin and Rajendra and Shwetha will make a presentation on SIAC rules and procedures. You can put in your questions during the SIAC presentation, and we will give you sufficient time and answer on most of the questions. With this, I now hand over the proceeding to Rajendra. Thank you again, Rajendra, for your time and efforts. I hereby hand over to you. Thank you.
Thank you, Zameer. Always a pleasure to be on a panel with you, and a privilege to be on this panel along with my esteemed panelists. Thank you to Lex Witness, to SIAC, and to the Society of Corporate Legal Experts for organizing this very topical, on a very topical subject. And thank you for having me here. 2020 has been the year of the pandemic, but it has also witnessed some very interesting judgments on the subject of arbitration, which has led to the development of the jurisprudence of arbitration in India. And what I will try to do, like Zameer explained, was that on some of these cases, I won't be able to cover all, obviously the other panelists will cover some of them. But on some of these judgments, I will attempt to give what are the findings, what are the judgments of the Supreme Court, some of the important ones. The underlying theme of my talk would be the issue of minimal interference in the enforcement of foreign awards, something which the Supreme Court in 2020 kept on coming back again and again. So that will be the underlying theme. And I will try to, of course, pepper it with certain other important judgments, which will give us some important learning. The first one is the judgment in Vijay Karya versus Prisnian, which the Supreme Court passed in February 2020, in which the Supreme Court upheld the principle of minimal interference in enforcement of foreign awards under Section 48. the Supreme Court refused to entertain pleas going to unfairness of the conclusions in the award, because the Supreme Court said that this was almost foraying into the merits of the case, something which is not permissible under Section 48 of the Arbitration Act. Just to recount, under Section 48 of the Arbitration Act, some of the grounds on which the Supreme Court may refuse to enforce a foreign award in India could be grounds like if the agreement is invalid in law, or if no proper notice of an appointment of an arbitrator has been given, or if a party has not been given an opportunity to present its case during the arbitration proceedings. And while dealing with the subject, the Supreme Court said that, for example, if no opportunity is given to the party to deal with an issue which goes to the root of the matter, which is getting decided, then obviously there is a ground for interference. But then when grounds are made out which get into the merits of the matter, the court will not get into that and will respect the arbitration award. So that is the underlying principle, that awards must always be read supportively with an inclination to uphold the award rather than to destroy the award, which has come about as a result of an arbitration proceeding, a forum which the parties have chosen. And now let me pepper that with a judgment which the Supreme Court came up in February 2020, which is Dharma Ratnankar Rai Bahadur versus Bhaskar Raju, where the Supreme Court said that if a document in which an arbitration clause is situate is not properly stamped, the court will not act upon that document. Now, that's a fundamental principle under the stamp laws of India, that if a document is not properly stamped, that document will not be given effect to. And the same applies even in respect of the arbitration clause or the contract under which there is an arbitration clause. Mankastu Impex versus Air Visual Limited, judgment of the Supreme Court in March 2020, dealt with the issue of seat of arbitration. And in this case, the place of arbitration, the venue of arbitration was decided by the parties to be Hong Kong. The question was, where was the seat of arbitration in this case? And the Supreme Court dealt with the matter, saying that seat of arbitration is a vital issue which needs to be decided, because the court of that particular area will then have jurisdiction to administer the arbitration proceedings. And in this case, while the contract did not specifically mention as to what was the seat of that arbitration, what the court did was, it said that the rules to be applied were, look at the contract, look at the other clauses, look at the intention of the parties, and then decide as to what could be the seat of arbitration. And in this case, while the arbitration was to be held in Hong Kong, the contract also had a provision that it would be administered in Hong Kong. And on that basis, the court decided that the seat of arbitration would be Hong Kong. Another interesting issue which has been going kind of, had been yo-yoing earlier, got decided this year by the Supreme Court. And the question is whether landlord-tenant disputes are arbitrable. And there have been varying verdicts on this in the past, but the Supreme Court in Suresh Shah versus Hi-Tech Technology in as recently as December decided on this subject and said that landlord-tenant disputes are perfectly arbitrable. The only exception to that is if the landlord-tenant relationship is governed by a special statute, for example, a rent control law, which creates a forum in itself, the rent control courts. If that is so, then the jurisdiction is ousted. Otherwise, the Supreme Court said that landlord-tenant disputes were perfectly arbitrable. June 2020 saw an interesting case come up before the Supreme Court, which was Centrotrade Minerals versus Hindustan Copper. Essentially, it upheld the principle that a two-tier arbitration was permissible in India. It's a case which has been going on for a very long time, and it keeps coming up. There was a point of time, I think in 2006, when the Supreme Court had actually held that a two-tier arbitration was not permissible. The contract in this case had 2 tiers, as in the first tier, the arbitration would happen in India under the aegis of the ICA. And the second tier was that if a party was aggrieved, it could again have an arbitration at the ICC London. What the Supreme Court in 2006 did was it said that this is not recognized and is non-est under the Indian arbitration law. It also intervened under Section 48. What happened in 2006 was there was a split verdict. Justice S.B. Sinha at that point of time said that this two-tier arbitration is a non-est, and therefore the whole edifice of arbitration collapsed. Whereas Justice Tarun Chatterjee, who was the other judge on the bench, said that no, a two-tier arbitration is fine, but then because HCL was not, which was the other party, the respondent was not given an opportunity to deal with its case before the arbitrator, the judge said that it merited an intervention under Section 48. And like I said earlier, under Section 48, Supreme Court or any court should rarely intervene except on the grounds which have been laid down under Section 48. So here Tarun Chatterjee Justice said that the grounds under Section 48 were made out. But because there was a split, the issue came up before a 3-member bench of the Supreme Court. In 2017, the 3-member bench actually upheld the principle that a two-tier arbitration was not non-est and that it was perfectly legal to have a two-tier arbitration. 3 years down the line, in 2020, June, the Supreme Court actually once again reiterated the principle of minimal interference in enforcement of foreign awards to say that the foreign award which had been passed was perfectly fine and there was no ground or no reason to intervene in this award which had been passed. Vedanta case again lays down the same principle, goes on the same line, and here was a case where the government was the counterparty and there was a $499 million award which was passed in favor of Vedanta and against the government of India. But applying the same principles, the Delhi High Court and the Supreme Court decided that the foreign award need not be gone into, and the enforcement need not be stopped because no grounds were made out under Section 48. I think I'll quickly deal with a couple of other cases before I conclude. I'm aware that I think I am overshooting a bit on my time limits, but a couple of interesting judgments which I will quickly go through. So this was December 2020, Supreme Court in the Anglo-American Metallurgical Company versus MMTC, where the Supreme Court, relying upon its previous case in Sudarshan Trading, holds that the Supreme Court will not reappraise the evidence which has been led in arbitration proceedings, and that the quality or the quantity of evidence which the arbitrator may have appreciated during the course of the arbitration proceedings and on the basis of which the arbitrator would have passed the award, the court will not once again get into that. And what the court has said is that the court will respect the choice of forum of parties. And once the parties have chosen the forum of arbitration, the power to appraise evidence has to be conceded to the arbitrator. And the court will not once again impose its wisdom on this whole issue, and therefore will not reappraise the evidence. An interesting but a very important principle which should be remembered. And the other one, of course, is that whether counterclaims can be filed in arbitration proceedings. And in the case of Ved Prakash Mittal versus principal of the Pirorimal College, the Delhi High Court in September 2020, going by the principles of state of Goa versus Parveen Enterprises, said perfectly possible to raise counterclaims in arbitration proceedings, provided that the arbitration agreement does not have anything specific with regard to only specific issues being referable to arbitration, because the court went by the principle that it is in the best interest of parties and all stakeholders to avoid multiplicity of proceedings. My last judgment for the audience would be the US Supreme Court judgment in the case of GE Energy versus Outokumpu Stainless USA, which came about in June 2020. Interesting, where the US Supreme Court said that a non-signatory to an arbitration agreement may compel arbitration under the New York Convention based on domestically available doctrine of equitable estoppel. Essentially, this was a subcontractor who was not a party to the contract between two people, between ThyssenKrupp and the other party, which was Outokumpu. And when arising out of a failure of certain goods which had been supplied, when a civil proceeding was started by one of the parties, the subcontractor, who was not a party to the contract, actually took a position to say that this matter cannot be adjudicated in court and that an arbitration must ensue. And the US Supreme Court actually upheld his contention and said, even though he was not a party, yet under the federal law of the United States, it was possible for a non-party to compel an arbitration in such a matter. I think I'll rest my case there.
Super, excellent. I think this was one of the wonderful. We wanted glimpse, and you really gave us glimpse, because these judgments are otherwise very substantive. You have just given us snapshots, and these snapshots and takeaways are really the most important part, and especially the US judgment also, which we cited. We have something very interesting also for the audience in the next step. Abhishek would now go forward and give us glimpses of some of the judgments of 2020 in arbitration matters, and one example of US judgment. Yes, Abhishek.
Yeah, thank you, Zameer, and good afternoon to all of us here. And I was just before we began the session, I was making a offhand comment to the other panelists that despite the fact that there is a lot of fog here in Delhi, and the morose aspect of that, I'm trying to bring a little bit of color to the session, and I hope that really helps in lifting the spirits overall for everyone. So there are about a handful of decisions that I would like to quickly take the audience through. We've had a mixed bag of these decisions. I think if I can perhaps try and classify the intent of where the law is headed and how the courts have dealt with the aspect of arbitrations, it would be largely, I would put it in the categories of those decisions which have furthered the entire concept of India as an arbitration friendly jurisdiction, both from the point of view of hosting arbitration as well as enforcement thereof, and those other decisions which could perhaps act as a spanner in the works with regard to these determinations. I think, but for maybe a couple, largely I would put all these decisions in the first basket, where there has been a concerted effort to push parties who have agreed to an arbitration as a choice of resolution of disputes to continue to go there. And in fact, even certain other parties who are claiming from the parties that are the original party signatories to the agreement, to push them towards arbitration as well. So all in all, I will start with the slightly, I would say, jarring note of the NAFED decision. This is NAFED versus Alimenta. Of course, this pertained to the 1980s position. So therefore, there is a bit of a jarring note, as I mentioned. But essentially, it dealt with a situation where the question was that in the event that there is what are the contours of interpretation of falling foul of public policy, and can the courts look into the aspect of violation of law as Indian law, that is, as a basis to say that this is violative of public policy, and therefore we will revisit this decision and not enforce it. This, of course, related to a situation where there was an export control order of 1980, which led to NAFED not being able to fulfill its portion of the contract. In fact, it was specifically prohibited from exporting the subject matter of the contract on account of a sudden increase in prices because of a natural calamity that had hit India at that point in time. And as a result of that, the contract was breached, and there was a determination where there was a judgment in favor of Alimenta, the international party. The award was passed under a specific set of, there is this Federation of Oil, Seeds and Fats Association, FOSPA, under which aspects of these issues are determined. There was an award in favor of Alimenta, and they sought to enforce it before the Delhi High Court. The Delhi High Court ultimately held the award to be enforceable, and it was taken in appeal to the Supreme Court. The question, the scope of challenge was whether an award that is brought for enforcement, if it is contrary to the public policy of the country, and what exactly it is that can be gone into to determine whether or not this would be violative of public policy. There was an issue of contingent contract in this particular matter, and if interpreted in terms of the Indian law, it would certainly have arrived at a determination in favor of NAFED and not Alimenta, as the actual award had been. Accordingly, the Supreme Court held that in this case, because this was hit by Section 32 of the Contract Act, it would amount to interference with public policy, and therefore they would hold the award to be unenforceable. My view personally on this is that given the fact that there have been other decisions of the Supreme Court where they have gone into consideration of the fact that pure violation of law may not amount to interference with or violation of public policy of the law of the country, it has to be something which is so basic and fundamental against the fabric of the law of India that only that can attract the issue of public policy. So to my mind, this was a slight jarring note and a departure from the regular line of decisions in this regard. The next decision that I'm looking at is the Edelweiss Asset Reconstruction Company versus GTL Infrastructure, which was taken up by the single judge of the Delhi High Court. It was a Section 37 appeal. And the point of law that was raised was whether the court, under Section 37 of the Act, can modify the directions issued by the arbitral tribunal. And the court, after appreciation of the issues involved and the decision in this, and also looked at the Supreme Court judgment in State Bank of India versus Ericsson, and it came to the conclusion that the powers of the court under 37 are wide enough, and they are in furtherance of the powers that are granted under 34. So while there will be minimal interference, and contours of that were expounded to a certain extent by Mr. Mishra earlier, but the contours of what will constitute minimal interference may differ from fact to fact and case to case. And therefore, the minimal interference will be warranted if the court has to protect the legitimate interests of a party that was not even, whose interests were not even disclosed during the proceeding before the arbitral tribunal. So the issue here was an award was granted between entity A and entity B. Entity A was supposed to pay that amount to entity B. However, despite knowledge, it was not brought to the attention of the arbitral tribunal that the first charge over the amount payable by entity A to B was actually with Edelweiss. And that's what was determinative in this matter for the purposes of exercise of discretion by the appellate court under 37 to protect the legitimate interests of the party. Next on, we have another judgment of the Delhi High Court in Dholi Spintex versus Louis Dreyfus Company, where the issue was whether or not two Indian parties, which are parties to a contract and where whether the substantive part of the performance of the contract is also in India, can they choose by contract the substantive law governing the contract to be a foreign law? And the court, to my mind, it's a wonderful exposition of the law, not only generically of contract, but also specifically with regard to the choice of parties that they exercise while entering into a contract, and specifically an arbitration agreement. And the court upheld the arbitration clause. And it also ruled that the scope of interference by a court in an international arbitration is limited to the court determining whether a valid arbitration agreement exists between the parties and whether the agreement is null and void, inoperative, or incapable of being performed. So the court will restrict itself to such a determination and go no further, specifically where the parties have categorically and specifically agreed to certain choice of law provisions. Another interesting decision of, and this is arising out of the Delhi High Court in NHAI versus Sehkar Global Limited. It went into the aspect of whether the change in law in terms of introduction of the GST regime operates as a force majeure event and may account for a frustration of the contract. In that situation, while the contract was entered into between the entity and NHAI, the GST provisions had not come into effect. And pursuant to the introduction of the GST provisions, there was an impact on the traffic that was being handled by this toll company, Sehkar Global Limited, as a result of which there was an impact on their revenue. And therefore, it resulted in a breach of contract of what were the specific terms between Sehkar and NHAI. Sehkar claimed that the enactment of the GST law amounted to force majeure event, and therefore it is entitled to a recovery of the amount that it was required to pay by NHAI, despite the fact that the GST provisions were there. The arbitrator upheld the arbitrator gave the award in favor of Sehkar Global, and held that the GST provision was a change in law and it was a force majeure event, and accordingly entitled Sehkar to recover that money. In appeal, and sorry, this was taken before the Delhi High Court under Section 34, and the Delhi High Court confirmed the finding of the arbitrator and held it to be a change in law necessitating a force majeure event. The last Indian case that I'd like to deal with is Noy Valencia Engineering, where the issue concerned, this is versus Jindal Drug, but the issue concerned whether a contract which is in the pre-Balco regime, and for the benefit of the viewers and the listeners, the pre-Balco regime was basically, in conjunction with Bhatia and the Venture Global series of cases that said that even the remedies set out under Part 1 of the Act could be resorted to in the case of international commercial arbitration. That position was changed in Balco. So the question that for determination before the Supreme Court was, where we are dealing with a contract which is pre-Balco, can the pre-Balco regime allow the parties to agree upon the seat of arbitration to be outside India? And then will Part 1 of the Arbitration Conciliation Act continue to be applicable or not? The Supreme Court held that to be not the case. It is a very well-reasoned, very short order. It is, in terms of this on the Supreme Court website, 33 pages. If you were to look at it in any other reporter, much shorter, but very succinct and very specific reasoning to come to the conclusion that the Part 1 of the Arbitration Conciliation Act will no longer be applicable, even though the contract pertained to the pre-Balco regime. In the US cases that I have looked at, specifically just one case, though it's a set of 7 cases that could be determining the outcome of what is likely to happen. There are a lot of these investment-related disputes, specifically inter-se countries within the EU, and these relates to the regime under ICSID. There were some regulatory changes in the Spanish energy laws, as a result of which quite a few of the countries invoked these investment dispute with Spain, and those resulted in certain awards being made against the Spanish government. There was some issue with regard to enforceability of such decisions inter-se parties within the EU, in light of the case that is now known as the ACMEA case. It is the Slovakian Republic versus ACMEA BV. And pursuant to that decision, it's become a little difficult to make these enforcements within the EU. As a result thereof, this U.S. District Court for the District of Columbia, stationed in the close to Washington D.C., has become the designated court, a go-to court for a lot of these awards to be enforced. And while a set of 7 cases are already pending, and some other cases that are, the latest among them was I think filed sometime in April 2020, and the first of those cases, which was filed in 2018, is now nearing judgment. So the decision in that particular case will decide the outcome and the future for these 7 cases. But pending that, the designated costs for enforcement of foreign arbitral awards, which is the DDC, which has become like the go-to court for this particular purpose, has seen a lot of activity specifically in relation to matters against Spain. And while there is no determination yet on this, it is very likely to be rendered as a judgment very soon. And thereafter, I think, depending on which way it goes, we're likely to see some activity of appeals, etc., going up all the way perhaps up to the US Supreme Court. And very interesting question of whether an investment dispute, the award of which is given within the EU and it's in between 2 EU countries, and because of the ACMEA decision cannot be enforced there, whether that can be enforced in the United States. So interesting times ahead, and I think the arbitration law and the development thereof will continue to keep us spellbound. And over back to you, Zameer.
Wonderful. I think beautiful. I think we are really privileged. We had first Rajendra, who gave us a snapshot of the Indian judgment and one example of US judgment of 2020. You gave us the snapshots of Indian cases decided by Court, Supreme Court, and US Court. The example which you gave is about a cross-jurisdictional issue and whether the United States will go into it. I think really a privilege, because we are getting a mammoth amount of knowledge today in snapshot so that it goes to our head directly without reading those awards and orders in depth. On my part, there are some judgments of the India courts, Supreme Court or the other courts, and one example of the US court, which I will cite to you. US judgment being very interestingly, because we talk about class suit, somebody came up with a concept of class arbitration. All right. So I first start with my India judgments. It's on section 2, whether an emergency arbitrator is outside the scope of section 21D of the Arbitration and Conciliation Act 1996 of India. All right. So this case came up for judgment on 21st December 2020. The parties are Future Retail Limited versus Amazon.com Investment Holdings LLC, prominently in news. The court relied on the decision of Evitel Post and held that emergency arbitrator is outside the scope of section 21D because the parliament did not accept the recommendation of the Law Commission to amend section 21D to include an emergency arbitrator. All right. This case is very much in limelight in India. The arbitration is on at SIAC. The judgment of Delhi High Court, where there were comments whether Amazon has also infringed upon the FDI rules, that judgment is proportionately in appeal at present. Matter is sub judice. We can't discuss more about it. But there was no stay which was granted against the emergency arbitrator award, which was given by SIAC. My next judgment before you is on section 5 of the Arbitration and Conciliation Act. This is an order of the court in September 2020, cases in the matter of Dinesh Gupta versus Anand Gupta, where again the question came up, and this has been coming up very often, and the courts have been also very bolstered and strong on it. To what extent can a judicial intervention in the interlocutory directions passed by the arbitrator, to what extent there can be a judicial intervention? The court once again emphasized that there will be a minimum judicial intervention with arbitral proceedings, and held that if the decision of the arbitrator is informed by adequate application of mind, it should be allowed to prevail, and interference in such decisions would do violation of the entire ethos of the Arbitration Act. My next judgment is about section 9, the interim relief, what we talk about under the Arbitration Act. This is a judgment of September 2020 in the matter of CRSC Research and Design Institute Group Company Limited versus Dedicated Freight Corridor Corporation of India. What is the scope of Section 9 of the Arbitration Act? Was the question which was brought before the court. The court relied on Avanta Holdings and held that following conditions are required to be satisfied before interim protection is granted under Section 9. Number one, existence of arbitration clause and manifest intention of the petitioner to. Number two, existence of a prima facie case, balance of convenience, and irreparable loss to justify the grant of interim relief. And three, existence of emergent necessity. So these are criteria which have been specifically now set by the court, and one has to be in the realm of these criteria to go before the court for Section 9 relief. The next case was very interesting. This order was given in November 2020. The case is Royal Orchard Hotels versus Kesholal Goyal. The question was whether the arbitration clause was binding the court. And the Supreme Court, the court relied on the Supreme Court's decision in Intel Technical Services Private Limited and held that language of the clause shows that the petitioner clearly had the option either to get the disputed adjudicated through the court or by way of an arbitration. Since the petitioner filed a Section 9 petition, the court held that the petitioner intends to get the dispute settled through the process of arbitration, and thus the arbitration clause is binding. The next judgment, which was on the question of whether it is binding on the court to follow the precepts governing the stay of a money decree under the Civil Procedure Code while dealing with an award, arbitration award under Section 36 of the Arbitration Act. Very interesting fact is that if there is a substantive law on the procedure code, and when you are adjudicating the same dispute under the Arbitration Act, whether the court, there is a binding to the court to follow the precepts on those particular award. The court held, this was a judgment in NHPC Limited versus Hindustan Construction Company, delivered in December 2020. The court held that comparison of Code of Civil Procedure and Arbitration Act shows that the both can be equated on certain basic principles, but at the same time, they are vastly different. Further, the language of the provisions of Section 36 of the Arbitration Act does not make it binding for the court to follow rules governing the stay of money decree, but only guiding principles. And therefore, there is no binding on the court to follow the precepts of the Civil Procedure Code in an award which is under Section 36, challenge under 36 under the Arbitration Act. The next judgment we have is under Section 37. What is the outer limit? Whether there is an outer limit of 120 days for filing an appeal under Section 37 of the Arbitration Act. This is a judgment between NTPC and Voith Hydro joint venture, a judgment delivered in September 2020. The court said the petitioner under the present case filed an appeal after 128 days, 128 days of passing of the judgment. The same was dismissed by the High Court as the maximum period of limitation to file an appeal is 120 days, citing the decision of Union of India versus Varindera Constructions and NV International versus State of Assam. The said order was challenged before the Supreme Court. The Supreme Court did not actually exercise discretion under Article 136 of the Constitution. However, it has now issued a notice on the question of law involved in these two earlier judgments, which means this will now open the gate for discussion once again, like we saw a very recent judgment of Justice Chandrachud, where the question came up that if a document, the stamp duty on a document if the document is unstamped, whether the arbitration agreement between the parties in that agreement can be used and whether arbitration can be initiated. So previous judgment says the document has to be stamped. It is not stamped. It has to be stamped and then brought before as an evidence before the court. Justice Chandrachud's recent comment on the judgment was that they don't agree to this principle. However, now they have recommended that this matter be referred to the 5 constitutional bench. My last Indian judgment is whether the court can appoint the arbitrator suggested by the respondent after the respondent has lost its right to appoint an arbitrator of his choice. This was a case between Tata Projects Limited versus Oil and Natural Gas Corporation Limited. It's a judgment of October 2020. The court held that there is no embargo on the court appointing the arbitrator suggested by the respondent if the court is convinced that the proposed arbitrator is suitable and qualified, which means there is another remedy on the equity side where the court has still intervened where the respondent had lost his right to appoint an arbitrator. My US judgment will be on class arbitration. This was a case Lamps Plus Inc. versus Varela. This is before the US Supreme Court, where the US Supreme Court considered whether a court can order class-wide arbitration when an arbitration agreement is ambiguous on the topic. Just to give you a short hint about what happened in this matter, the dispute arose out of an employment contract. The agreement contained certain provisions that might be interpreted to contemplate individual arbitration, while others appeared to contemplate a possible class or collective arbitration. The US Supreme Court held by a 5-4 vote, so it was heavily debated, controversial judgment, that an arbitration agreement that is ambiguous as to the availability of class arbitration does not provide sufficient consent in order to submit a dispute to class arbitration under the Federal Arbitration Act, FAA. In so doing, the court recognized that class arbitration is fundamentally different from individual arbitration protected by the Federal Arbitration Act. Accordingly, the Supreme Court of United States reversed the Ninth Circuit's decision and in so doing rejected the application by the Ninth Circuit of California contract interpretation doctrine that constitutes ambiguities against the drafter on the basis of such doctrine was effectively preempted by the Federal Arbitration Act. All right. So it has now reversed the judgment saying that if there is an ambiguity, which means there is no consent, and therefore there is no protection in the nature of individual arbitration, which is protected under the Federal Arbitration Act, and therefore there can't be class arbitration in the matter. So this is my part of the presentation on the India case study and one example of US case on arbitration. With this, I now hand over the charge to Kevin and Shwetha to make a presentation on SIAC rules and procedures and highlight the importance and the interpretations which are required in terms of engaging the services and forum as SIAC, Singapore International Arbitration. Kevin and Shwetha, handing over to you. Thank you very much.
So thank you, Zameer, and thank you, Lex Witness, for organizing this, and everybody who's staying up on a Saturday evening to hear us. We'll try and make it quick and sort of cover the important points that may be of interest. First is to understand what is the constitution of SIAC, who are the main people, the heart of SIAC, which has made us where we are today. To understand the main rules, which allows parties to save their time and cost. Then also a very important factor, I think, particularly, not just from different parties, but from Indian parties' perspective, to understand how the costs are calculated, how are the deposits paid. So this is essentially what we're going to cover. But please feel free if anybody wants to understand any other specific aspect, or Zameer, Abhishek, or Rajendra, if you have any question, we'll try and take that up, within the limited time that we have. Sure. So I'm just going to start with the presentation. Can you see the screen? Yeah, okay, great. So this is what I intend to cover, and I've already sort of set out that in brief. Overview of SIAC. So of course, SIAC is, amongst the top institutions in the world. In fact, in terms of the caseload of internationally administered cases, even from last 5 years surpassed even LCIA. We began our operations in 1991. So this year is effectively, we'll be celebrating our 30th anniversary of being founded. 2020 was a very significant year. Of course, it was a difficult year for a lot of us. But in terms of caseload statistics, SIAC saw a historic number of over 1,000 cases in a single year. In fact, although SIAC is based in Asia and in Singapore, and that's where it also sort of derives its prominence from, but 80% of the cases that we see at SIAC are actually international and have nothing to do with Singapore. The awards that have been passed by SIAC have a proven record of enforcement in multiple jurisdictions across the world, including, of course, India, China, Hong Kong, Europe, and of course, the US. Like I said, and Zameer also very kindly introduced, when he was mentioning and talking about SIAC, that SIAC has been known for innovations in its rules. So SIAC has really stayed ahead of the curve and taken the initiative to make the changes in its rules that were required. In fact, for some of the rules, SIAC was the first institution in the world to introduce those rules. So I'm going to now just quickly go over first the recent trends that we're being seen at SIAC. The statistics for 2020 hasn't been released officially yet. So I'm going to still focus on until 2019. But I've of course mentioned that in 2020, we saw a landmark of about over 1,000 cases. So this is really what the number of new cases has been for SIAC in the last 29 years. So having a humble beginning in 1991 with just 2 cases to now in 2020 to over 1,000 cases, I think SIAC has come a long way, but it still has, a long journey to cover ahead. This is a snapshot of the top 10 foreign users. So of course, I think maybe some of you may already know that how India has been amongst the top foreign users for India, in the last 5 years. And that has really been due to the trust and the credibility that we've seen with Indian parties arbitrating at SIAC. So in 2019, there were over 485 Indian parties that were arbitrating at SIAC. These are the categories or the sectors of dispute, where the arbitration matters come from at SIAC. So this really is a wide range, from commercial to construction to maritime shipping to service, corporate and trade. So all of the sectors really, you see a mixed bag of cases that come at SIAC. This is India-specific number, where majority of the cases have been from the corporate sector and followed by construction, trade, and commercial. This is what I mentioned about 2020 being a record year for SIAC. Of course, the statistics will formally get released later this year, and we will have more details in terms of number of foreign parties, etc. Now, SIAC's people, which I think is really the heart of SIAC, and I think everyone can really vouch to that an organization becomes what it does because of the people at it. And really, I think SIAC's heart is this: the board of directors, the court of arbitration, the secretariat, and the panel of arbitrators that SIAC has. Essentially to just understand what their functioning are, and I'm not going to get into too much details, but to give you a very broad overview, there is, of course, the board of directors, which is chaired by Mr. Devinder Singh, who's a senior counsel and very well-known counsel in Singapore. The purpose of the board is to really oversee the corporate governance, the business development and operations of SIAC. From India, we have Mr. Rajiv Luthra, who's part of the board of directors of the SIAC board. And then the court of arbitration, which is headed by the president, who needs no introduction, Mr. Gary Bourne. So there are 32 arbitration practitioners from across the world. And this is really a mix of arbitration practitioners from civil law and common law jurisdictions. So all of them are very well-known names, and it's the court which really oversees, or supervises the case administration and performs various quasi-judicial functions. So the president, which Mr. Gary Bond, he appoints arbitrators, and he determines, some of the important applications, which include expedited procedure and the emergency arbitrator applications. So when an application is made, whether a case needs to proceed for expedited procedure or an emergency arbitrator needs to be appointed, it's the president who takes the call. Then the Court of Arbitration, which usually on a case-to-case basis functions by way of a committee of the court. So it's not that all 32 court members sort of sit on each case, but there is a committee that is formed on each case. And the court decides the applications for consolidation, whether multiple arbitrations can be consolidated, whether a party can be joined who may be a non-signatory to the arbitration agreement, any challenge to the arbitrator, prima facie jurisdictional objections, and also if required, in terms of the scrutiny of award, certain questions can be directed to the court committee. Court is assisted by registrar, our deputy registrar, who's Kevin Nash, and the secretariat. So this is just a snapshot of a quick look at who the board is and who it comprises of. And this is the Court of Arbitration. From India, we've got Mr. Harish Salve, Mr. Darius Kambata, Tejas Karya, and Shaneen Parekh. And like I said, that it's headed by President Mr. Gary Bond and our two Vice Presidents, Mr. Kevin and Professor Lucy Reed. In terms of the Secretariat, which is seated in Singapore, so that we have a team of multilingual and multinational lawyers, and that's precisely because the cases come from so many different jurisdictions. To be able to understand the nuances of each of these jurisdictions, it's important to have lawyers who are well versed with these different jurisdictions. In fact, from India, we have two counsel who are part of the Secretariat. What does the Secretariat actually do? What does SIAC do in a case? So of course, from starting with the appointment of arbitrator, which is essentially really the most important function, as we say that an arbitration is as good as the arbitrator sitting on a matter. While the parties in general have the right to nominate an arbitrator, it's the president who really enjoys the discretion to approve any arbitration appointment that's done. So any arbitrator appointment in an SIAC matter goes through the president, which is Mr. Gary Bond, to be confirmed and affirmed. In fact, where parties are not able to agree, in terms of nominating an arbitrator, even those appointments are made by SIAC. And when I say that this function is essentially so important, because to know and understand different arbitrators, to understand, what their experience has been in the past, and to be able to appoint the right arbitrator is such an important part of the function that the Secretariat undertakes. Secondly, is about supervising and monitoring the progress of the case to ensure that there are timely compliances, there are timelines that are set, the costs are not escalated in a matter, the financial management to be able to determine what the cost is going to be, how much the deposits are going to be paid. All of that is taken care of by the Secretariat. Again, lastly, and if Kevin wants to jump in here and say, please feel free to add, is really very, very important function of the Secretariat is the scrutiny of draft awards. And this is the process which really, I think, sets SIAC apart amongst the top institutions in the world. There are only few institutions which actually undertake the process of scrutiny. But even amongst those who do, the timeline with which SIAC is able to really come back and complete the scrutiny, with that sort of efficiency and a value add is what has been really setting SIAC apart, and is if I can say, is attributable to making SIAC really gold standard in its case management. Some examples of what the scrutiny entails. So of course, when an arbitrator gives a draft award, it first comes to SIAC. It is not transmitted to the parties straight away. We at SIAC, and which includes multiple layers, of course, the counsel in charge in a case, who's well versed and who's been involved in the case right from the beginning to the end, will look at different aspects that are set out in the award, starting with the procedural history and ensuring there are no procedural irregularities that the tribunal needed to address. All the issues have been completely and accurately set out. What are the issues that were raised? Have they been decided upon or not? And everything has been determined. If there are determinations, that are made by tribunal, to ensure that those are not outside its jurisdiction, and to ensure that all issues that were raised in the case, the parties have been given the opportunity and those have been addressed in the award itself. So this really minimizes any scope of error or challenge, which essentially is a very important part, because you may get an award, but if it gets challenged and set aside, then it's merely a paper and loses its whole value. So scrutiny is a very important function that enhances the enforceability of awards, because the Secretariat is able to add those extra pair of eyes, to ensure that these compliances are in order, which itself does not become the ground for challenge. In fact, on certain substantive points itself. So, of course, while the registrar undertakes the scrutiny, it is not replacing, the work of the tribunal, but it can bring to the attention of the tribunal the points of substance as well. In fact, on certain points, if required, the registrar may also consult the SIAC Court of Arbitration, which of course includes the world-renowned arbitration practitioners. Next is the SIAC panel of arbitrators. SIAC maintains a panel of arbitrators from different jurisdictions across, including, of course, from India. We've got a number of arbitrators. We have over 500 arbitrators on the panel. But interesting to note that SIAC is not limited, when it makes an appointment to the panel, which is only listed on its website. So SIAC may appoint arbitrators outside the SIAC panel. In fact, the parties can also nominate an arbitrator who may not be sitting on the panel of arbitrators. The entire process of appointment and being on the panel is extremely rigorous. There is an executive committee of SIAC, which comprises of the president and the vice president, which undertakes, in determining, whether an arbitrator is sufficiently qualified, has the relevant expertise and understanding to be a part of the panel of arbitrators. Over the years, of course, there has been some concern about gender diversity, and SIAC has really stood in the forefront to ensure that even on this aspect, we really be able to trailblaze. In fact, from 58 of 159 arbitrators that were appointed in 2019 were women. So this is really a substantive increase of about 34% of arbitrators that have been appointed by SIAC. Just quickly and really a snapshot, which is Zameer's go-to word, to get a snapshot of everything. And this is what I'm going to try and concisely put together, which are very, very important mechanisms in an institutional arbitration. And particularly when I say SIAC, is because SIAC has really innovated some of these important mechanisms, which has allowed parties to save time and cost. And of course, we've all been reading in the news about Amazon and Future Retail's case, and this is where it begins, and I think there's a lot more interest in India, particularly after this case, than ever before, because India is really now, with the Delhi High Court judgment, and Justice Mukta has clearly set out that it's not that emergency arbitrator is outside the purview of Indian Arbitration Act, and I think, while there have been slew of judgments before where they had indirectly recognized and enforced, this judgment has really, I think, put it very clearly that emergency arbitration is recognized and is not outside Indian Arbitration Act's purview. So what is the benefit of emergency arbitration? And this is something that you can only get in an institutional arbitration, is when the timelines are tight, the confidentiality needs to be maintained, right? And you can't wait to go to the court and get a decision, is really where the use of emergency arbitration is. So you can get your arbitrator, emergency arbitrator appointed in one single day. And it's not even one working day, it's one single day. And as Kevin often mentions, that most of the applications would come on a Christmas Eve, or on a Friday evening, and the weekend goes into sort of getting an emergency arbitrator up and running. And in fact, very important is the timeline within which the emergency arbitrator is required to issue an order on award. This is exactly 14 days from the appointment. So the timeline for emergency arbitrator is extremely tight, to ensure, of course, the urgency in a matter, to be able to cater the requirement in a case. Second, very interesting, and I think even more importantly in the last few years, is the expedited procedure, which allows for cases which are under the value of about 6 million Singapore dollars, or where the parties have agreed, or where there is an exceptional urgency, to have the case decided within 6 months. So you don't even have to wait, to run the proceedings full blown, and can have the case decided within a matter of 6 months. In fact, in some cases, the tribunal can also decide to hold documents only proceedings. So you don't need to have cross-examination of witnesses, you don't need to have hearings. In fact, in the last year, during the pandemic, we saw a number of requests for documents only proceedings, because the parties were really concerned, A, about the costs due to the liquidity crunches, also B, about not being able to sort of hold hearings, and we're also skeptical how the virtual hearings may go on. So expedited procedure, I think, has been a very, very popular mechanism that the parties are more often now resorting to be able to save their time and cost. Third, early dismissal of claims and defenses, which is sort of a mirror to what we have in litigation, summary dismissal, is when you have a case which is manifestly without legal merit or manifestly outside the tribunal's jurisdiction. You don't have to wait for the entire case to go on and then have an arbitrator's decision to be said that the case has no merit or it's outside the jurisdiction. You can file an application for early dismissal right at the beginning and can really save all that cost that you would have spent in running the arbitration and the time that would have been spent in the arbitration itself. Consolidation and joinder, again, an important mechanism which allows for multiple cases. And I think this is very relevant. Maybe, Rajendra, if you see a lot of these multiple contracts that are signed with subsidiaries and the holding companies, etc., and how, if there is an arbitration agreement in one and you want to join a party from the other, maybe a holding company or a subsidiary company, how that can be brought within the purview of the arbitration in question. And consolidation, again, very important, because you don't have to run multiple parallel proceedings. You can consolidate these multiple arbitrations into one arbitration itself. So that also saves the cost for not running multiple arbitration, and also any inconsistency in the findings, by the different tribunals. Again, one more important part, and then I'll just quickly turn over to Kevin, is an interesting protocol of Arb-Med-Arb, which essentially, like these days we've been hearing, and especially when I've been speaking to a lot of corporates recently, is a focus on settlement, and how can you have an effective settlement, with, and Arb-Med-Arb protocol really is the answer to this. So which allows for you to commence the arbitration and then move to mediation. In case there is a resolution in the mediation, then you're able, your settlement, is turned into an arbitral award, which has the advantage and enforceability under New York Convention. So this is very, very interesting, and it really allows party to have an effective mediation in that sense. Lastly is the remedy against a non-paying party. Again, a very important concern that lot of users have is, what if the other party does not pay its own share of deposits once the arbitration begins. So essentially it is that each party will pay 50% of the deposits that is called on by the institution. So under this mechanism, you can really approach the tribunal and ask for an order to be passed, against the non-paying respondent, or where the party is not paying, to pay its own share of deposits. So I'm going to skip all of this in the interest of time and quickly run to cost and ask Kevin to please. Kevin, over to you.
Take your time. I mean, we are really interested in the subject. So
okay.
Yeah, please.
Kevin?
Thanks, Shwetha. Thank you to the organizers and my fellow panelists. I really enjoyed all of the interventions. One thing that's important to note is the connection between SIAC and Indian parties. Indian parties in 2019 were far and away SIAC's top foreign user. So much of these procedures that we're looking at, and when we're designing them, we're looking at how is this going to work for Indian parties. And what we're really trying to promote are the advantages of institutional arbitration. Why would you choose institutional arbitration as an Indian party? And part of the reason that you would is because it does stand to lower the time and cost of arbitration. Now, arbitration is still a party-driven process. It should be exactly as fast as the parties want it to be. What you do not want in an arbitration is unbargained delay. When an arbitration somehow gets a bit off the tracks, you may have a non-participating respondent, an intermittently participating respondent, and in the ad hoc context, this might add months or years to an arbitration. And there is a direct relationship between the legal costs and the duration of a proceeding. The longer a proceeding, of course, it only stands to reason that the legal costs are going to be higher. What's interesting and particularly relevant at SIAC is our cost system. So our cost system for the institutional costs and the tribunal fees are based on fixed fees. So they're subject to a maximum. So regardless of how long the arbitration takes, these costs are going to be the same. There is cost certainty at the outset. So from a corporate counsel standpoint, at the beginning of an arbitration, you know your maximum exposure for the institutional fees, which are a very small percentage of the overall fees, of course, and your maximum exposure for the tribunal's fees. And so once you have these maximums, an important part of what we do is that then we have a rigorous cost determination process. We look at these maximums and then we look at what's actually happened in the arbitration and fix a proportion of these fees from what's actually happened. So what you have to do is you really do the forensics on an arbitration. For any institution, if you're a user, you do not want an institution to be mechanical and just automatically awarding, say, the institution 100% of the maximum fees, 100% of the tribunal fees. What really happened in the arbitration? And because we have the scrutiny of awards and structured administration, we can see the lifespan of an arbitration. We know what's happening at every stage, and then we're able to fix the costs in a way that makes sense for the work actually performed both by the institution and by the tribunal. Another institution did a study on how, what is the proportion of all of the costs in the arbitration? And it turns out that it will typically be about 2 or 3% for the institutional fees. So it's a very small price to choose institutional arbitration. The arbitrator's fees will be around 17 or 18%. And then it's the legal costs of paying counsel that will be about 80%. But as mentioned, the reason why these legal costs can sometimes get quite high is because an arbitration, if it's taking many years to complete, of course, the legal costs will increase. We do try to infuse flexibility into the SIAC system as well. Every case is different. So if parties want to agree to a different form of remuneration for the arbitrators prior to constitution, that is completely possible. It doesn't happen very often. I do think the parties see the advantage of the fixed fees, but parties will sometimes agree to an hourly rate for arbitrators, an hourly rate subject to a maximum, and that is completely within the autonomy of the parties. So these are the fees, and then, but because arbitrations have to be funded, there's also deposits that are payable to the cost of arbitration. And sometimes users, if it's their first institutional arbitration, find it a bit surprising that you have to pay upfront for the deposits towards the cost of arbitration. And these are deposits. That's just to secure the fees of the arbitrators and the institution. And what we want to do as an institution is we want to make sure that these deposits make commercial sense. Particularly during COVID-19, some companies are a bit more cash conscious. We are certainly alive to this fact. And so we're trying to call for those deposits in a way that makes sense. Shwetha, if you could go to the slide on the institutional comparisons. And I think what you want to see here, and this really is just giving an indication that all institutions are prioritizing costs, the efficiency of an arbitration. So you can see that SIAC fares very well as measured against other institutions. But again, every arbitration is different. If you have a $5 billion case, a $7 billion case, the cost might be different, and also different costs depending on whether it's a sole arbitrator tribunal or a 3-member tribunal. As mentioned, we are in a rules revision right now, so we plan on releasing the SIAC rules 2021 later in the year, and certainly we're looking at ways that we can make arbitration even more efficient, and we will be soliciting a lot of comments from our Indian users. Now, one thing about effective case management is that we do always want to hear from the users, so I don't want to take too much time, and certainly if there's any questions on our processes and procedures for administering these cases, we would certainly be happy to take these on.
Sure. I think Kevin very rightly said by you. I think what I could garner being in this field, I'm also a trained mediator. You spoke on 3 aspects, which is what is the awareness conscious, which is conflicting in the arbitration space we have here in India. It's about cost, it's about the speed, and it's about the efficiency. So when you said that the awards, which are also draft awards, which are under scrutiny, sometimes it's the efficiency of the arbitration award also, which is under question, maybe on the technical ground of it, but otherwise law seems to be taking care of it. But I think it's the cost, it's the speed, and it's the efficiency of the forum itself, which is there. And I think your PowerPoint slide addresses all 3. I think it's the awareness which should be there more in India, because in India, we do have ad hoc arbitration. We do think about institutional arbitration. But these are the 3 factors which, when the Arbitration Act came into force, these were the 3 factors which were considered, that it was supposed to be cost effective, it was supposed to be faster, it was supposed to be efficient. It may be there in many of the cases, but this goes into the mind on discussion points, whether this is there. And I think SIAC has been playing that role. I have shared earlier with Shwetha also during the days of Tata Docomo dispute or the present Amazon dispute. SIAC has been in forefront on the awareness portion of it. We should be there more in India, because I think the slides what you showed us really inclines the corporate to look into it. Because as a general counsel, when we approach our top management for certain matters to be referred to arbitration, these are 3 factors which really also make a difference to our lives, because we are putting our professional eye on the forum of choosing it, and which is what we are looking at the best interest of a company. And we are really looking out for such forums which can address it faster. I would add certainly one more thing, that the emergency arbitrator award in the Amazon case also, which was there before the Delhi High Court, and the Delhi High Court did not state that order, really goes down well, because even yesterday when there was a discussion on some other portion in the professional life, it was when do you file it, when the arbitrator will be appointed, how much time it will take, and by the time it is done, whether the remedy will be available or it will be in fractious. We were discussing on Section 9 and other things. So I think it really makes a difference when this emergency arbitration was held, and Delhi High Court also did not stop it. It makes a difference because it sets a precedence in the mind of the intellectual legal fraternity also, that this is a forum available and this is the emergency arbitration, which is available to you for reliefs, emergency reliefs if required, in addition to Section 9, which is always there under the Arbitration Act to us. With this, the 2 segments, one is updating you on the arbitration developments in 2020. We presented to you snapshots of about 18 to 20 cases. We wanted to keep it snapshots so that you have a lot of pickups for your home. And second, the awareness on the SIAC as a alternative dispute resolution forum. Shwetha, I would also like to point out that the ARB-MED-ARP model, what you have spoken, is really important, because when we used to sit in that forum as an arbitrator, we would see that there is a caucus which is there. But the mediation panels then later on helps, because in the first phase of the first leg of the ARB, the reality check and all those things have been looked upon through the evidential eyes, and therefore ARB model would also really make a difference to life of people. It helps to resolve the dispute on the settlement side of it. Not only it saves the cost, but it also saves the productive time of all the parties who are involved in the process. We have few question answers which are there, and I would just raise those questions to the panelists, and we would try to answer as much as possible in the times we have. The first question, Kevin, I would ask you, and Shwetha, you can join in because it's from the SIAC side. Delhi High Court did not state emergency arbitrator award. Do you think that this will really bolster emergency arbitration award, considering the timeline in India, timelines which are there in India? Yeah, any point of view?
Sure, I will address it quite broadly. What's been really exciting about the SIAC emergency arbitrator procedure, because we've done more than almost any institution in the world, and India as an arbitration jurisdiction, this is now the fourth decision from the Indian courts that are really becoming seminal decisions that the entire world is looking at. I sit in INCITRAL Working Group 2 discussing fast track procedures for the INCITRAL rules, and the entire world is looking at these Indian decisions. So I think it's a great boon for emergency arbitration. What we're always trying to point out for users is that emergency arbitration is not precluding applications to court. These can be done in complement. So you can make an application to the court, say in Singapore, with a Singapore seated arbitration if you need relief against a third party. But exciting developments, and it's really interesting how SIAC and the Indian courts are helping move forward emergency arbitration.
Yeah, because, for us, it was not only in the newspapers, but in the legal fraternity also, like you call your WhatsApp group, etc. So this was all over the place, and people really look forward that if this is the relief which is available, and this was really a big case, so it got a little more highlighted on the front. All right, thank you. My question is to Abhishek. Can you throw some light on arbitrators' fees in cases? Okay, this may also go to SIAC. Can you throw some light on arbitrators' fee in cases where the disputes are getting settled and the award is basically a consent award, and also on the stamp duty payable on it, and if the award was to be on an Indian award? I think, Abhishek, you can say that. I thought it's on the SIAC side, but I think you can answer this question.
Yeah, so actually, Zameer, I very recently was part of a matter where pretty much after the first initial meeting itself, where the broad contours of the dispute was being relayed to the learned arbitrator, and with the indulgence of the arbitrator, a little bit of a push and a shove from him, parties were able to sit down and resolve the entire issue. And this is the second instance, and I'll give you both resulted in contrasting results. So the latest one was where the arbitrator just left it to the parties, and because the parties had resolved their dispute with consent, parties were also able to resolve what they had both agreed to pay the arbitrator. And we didn't really refer to either the schedule or any other methodology to determine it. It is just an ad hoc sort of amount that was agreed upon, and the arbitrator graciously accepted it. In another case where perhaps it was very early in the arbitration, I think the statement of claim had not even been filed, and the arbitrator did say that while, of course, we facilitated the settlement and it's over, however, we would apply the principle of the schedule and come out with a determination of the fee that is payable because of the fact that parties have settled. So therefore, the arbitrator said that we'll give you a 50% discount on whatever that amount comes up. Okay. So I think it's very discretionary, and it completely depends upon the tribunal as to what they would perhaps like to do. And also it will depend also on what stage the consent award is being passed.
Wow, wonderful.
May
I think,
I add to that?
yes, please. Yes, please.
I just want to intervene because of my own experience. So we were in an arbitration in India and a very senior arbitration panel with retired Supreme Court judges. And after the claim and the response, etc., were over, pleadings were over, the issue got settled. To our pleasant surprise, the arbitration fees, which as per the order had been paid in advance, we got a refund from the arbitration panel, not at our asking. They approached us to say that we will charge you only for those dates on which we held the hearings, and those were very preliminary hearings. So the balance money got refunded to us. So
Wow.
that was a pleasant surprise. But yes, as Abhishek said, I think it's entirely discretionary and depends from panel to panel. I think the other limb of the question was that on stamp duty of the award. And I think in Maharashtra it's 500 rupees if I'm not wrong.
Yes.
But the stamp duty, of course, as you know, varies from state to state and would then depend upon the schedule. I think for Delhi it is different, 0.1% of the
0.1%.
Right. And on the stamp duty portion of it, while this was under discussion, what we were referring on this question which has been asked is that the question before the Supreme Court was whether non-payment of stamp duty on commercial contract will invalidate arbitration agreement. And the Supreme Court, the judges comprising of Justice D.Y. Chandrachud, Justice Indu Malhotra, Justice Indira Banerjee, have recently referred the matter to a constitutional bench on the question, and the question is here, whether the statutory bar contained in Section 35 of the Indian Stamp Act, applicable to instruments chargeable to stamp duty under Section 3, read with schedule of the Act, would also render the arbitration agreement contained in such instrument, which is not chargeable to payment of stamp duty, as being non-existent, unenforceable, or invalid pending payment of stamp duty on the substantive contract or instrument. That's the question which has been now referred to the constitutional bench, where there is a insufficient stamp duty and therefore question on the arbitration agreement itself. My next question is to Kevin and Shwetha. The question is to bring little smile on you. The question is, will you add more SIAC offices in India?
Shwetha, I defer and pass to you. You are responsible for such a big jurisdiction.
All right. This is just to bring the smile while we go on the legal questions. There are some other questions we have got. Okay. Rajendra, how do you see the decision in the SIAC case making a difference to the Indian legislation? So the Amazon Future judgment, where emergency arbitration award was not stayed, how do you feel? What do you see that will there be a difference in the Indian legislation where there will be an amendment or a call for amendment, or it would be a judicial precedence which will now continue lifelong?
I feel that it will be moving sands, so we will see how things pan out. But certainly there'll be call for amendments which will come. But as usual, I think the Indian legislative scenario, the jurisprudence will continue to develop basis some of these leading institutions and their processes and their procedures. and of late, the Indian law has been adapting to the latest, which is there on the worldwide scenario. And SIAC is one of the leading institutions of arbitration that we have. And I'm sure that the awards of SIAC would continue to inspire changes, not just in India, but across the world.
Okay. I think we had one of the rich, knowledgeable sessions from everyone. I really want to thank you. We are just 10 minutes. We have offshooted our time, and we have some questions. You can connect with all of us on LinkedIn. We really welcome you on that. I would now like to thank my panel members, Mr. Rajendra Mishra, Mr. Kevin Nash, Mr. Abhishek Malhotra, and Ms. Shwetha Bhiduri. I would also like to thank Lex Witness, SIAC, Society for Corporate Legal Experts for putting up this great event. And finally, thank you so much to my wonderful audience for your patient listening and support. We had a lot of content for you because we wanted to give you in the simplest form, where we presented the judgments to you, India, US. We gave you a glimpse of how the SIAC proceedings work, a lot of inputs from SIAC panel members, which inclined towards choosing ADR as an alternative dispute resolution mechanism, and hopefully arbitration gets more positive signal in India, and we grow adjudicating matters in this forum, because arbitration, ultimately the objective was on the basis of the cost, timelines, as well as the efficiency of it. And if we have good forums like SIAC, I think we would have good judgments coming out of it and good precedents setting about it till the Supreme Court hears the matter on the same. Thank you once again to everyone for listening patiently and your support. Have a great weekend and a very happy new year to everyone. Thank you once again to everyone. Thank you.
Thanks, Zameer, for a great
Thank you so much, Zameer, sir.
moderation.
Thank you so much
Thank you
to
so
all the
much.
attendees
Thank you.
and the esteemed panelists. Zameer, sir, seeking your permission to end the webinar for everybody now.
Yes, please. Go ahead. Thank you, everyone.
Thank you so much.